Hello, my name is Andrew Feldstein, and thank you for joining us on the Ask Andrew Show, Canada's first live Facebook streaming family law question and answer show. Today, we're going to have as our guest Elizabeth Hyde of Riverdale Mediation. They provide comprehensive family mediation, conflict resolution, and negotiation services. They actually also provide training for lawyers such as myself, and I've taken them for training services in the past and have always found them to be very good for anybody who's watching and thinking about needing some training in those areas. As a mediator, arbitrator, and parenting coordinator, Elizabeth is here to speak to us today primarily about parenting coordination and how it can assist parents in resolving their matters. So without further ado, welcome Elizabeth, and thank you for joining us today.
Thank you, Andrew, for having me.
It's a pleasure. I want to start with, so people can understand, what is parenting coordination?
So parenting coordination is a bit of a hybrid process. It is for people who have a final parenting plan, separation agreement, or consent order. So they've already agreed to the terms of their parenting plan, but they're having a challenge actually implementing that plan. So they may have a communication issue. There may be difficulties with how they interpret that plan. And so the PC is not only there to assist with those conflicts, but also to do some education upfront. So maybe it's coaching on better communication skills. It's talking to them about where the kids are at on a developmental scale. So it's a little bit of a hybrid model. And then in the event that they actually can't resolve a dispute through that process, then the parenting coordinator has the arbitral function where they will make the decision for them.
Now, one of the things I see in my practice is we will frequently have an agreement, a referral to a specific parenting coordinator. Mm-hmm. And one of the challenges I have with other lawyers is I'm a big believer now in getting the agreement basically signed up concurrent with the agreement that would be settling the dispute between the parties. And I've seen a lot of cases where they may say, we're selecting Elizabeth Hyde to be the parenting coordinator and the parties will execute her standard agreement. And then a year goes by, there are no issues, and now somebody wants to hire Elizabeth and somebody says, I'm not signing the contract, mm-hmm. giving the retainer. I don't know if that's something you see often and how you would deal with that.
I do see it often. It goes often into orders, consent orders. And, I may not be able to take the file at that point in time. I see orders or agreements where they say they're going to do open parenting coordination and I only do closed. And the case law really suggests that unless I or whoever takes the file does the intake and the screening and says it's appropriate to move forward, all they've done in the previous agreement is agreed to agree in the future, that it's not really enforceable because you don't know what the situation is at the time that they actually come to you. So part of the intake process is screening for power imbalances and intimate partner violence. And in the event it's not appropriate to move forward, then it doesn't matter whether they agreed in the past to parenting coordination.
Now, this is why I say to my clients, it's a good idea. You're wrapping up the case. You have the draft separation agreement. You pick the parenting coordinator, get the agreement signed up. Go get, if the person wants, which you actually have to have the screening for domestic violence done, go get it done right away, because inevitably what will happen is when you want that person's assistance, there's going to be something urgent.
Yes.
And somebody like you is going to say, well, I got to do my screening first. And these are my dates for my screening. And this is the timing. And when people want it fast, this is a great way to delay the process.
Yes, it is not a speedy process to get started because not only do we have to do an intake with both of them and do the screening piece, then the agreement has to go back to the lawyers for execution and independent legal advice. So if there is a delay in that process, it can often take months before you actually get people into the process. Usually, if we get them started, then everything is set up for the urgent issue that invariably will pop up. Oftentimes, people don't actually engage you until that urgent issue, and then it's a bit of a flurry trying to move things forward.
And the other interesting thing is when there's an urgent issue, sometimes both parties generally want a resolution to that urgent issue. But other times when there's an urgent issue, delay favors one party.
Oh, absolutely.
And when delay favors one party, it's unbelievable how, at least in my experience, they're not available. They make it difficult. They may even tell stories at the screening for domestic violence, hoping that you're not going to find it suitable. So again, if you do that right at the time that you're doing the separation agreement, when both parties want to be engaged in the process, it's the right time to be doing that.
Well, I mean, if it's a long period of time between screening, I would have to rescreen anyway. I mean, my view is if both parties are not buying into it, it's not going to be a successful process. You need both parents engaged and willing to not only do the homework, do the upfront work, and it's not an index, like it's much less than litigation, but it's still another fee for service process. So, and if you're having to drag one parent to the process, it's probably not going to be successful at the end of the day anyway.
Well, except you may end up with an arbitral award that deals with the issue.
Absolutely.
Yeah. As some people doing your job say, sometimes somebody needs to call the balls and strikes with more efficiency than a judge can.
They do. Absolutely. And that is part of the process. We would say less expensive, much faster. And at the end of the day, it's a process that people, if they're happy with the result, they'll continue to be engaged. The person who is unhappy with the result, again, a little bit more work to get them back into the process. But it's clearly a better process from my perspective than repeatedly going back to court on motions for things that really just don't warrant it.
Now, I'm going to start with, and I want you to confirm this for the audience, that a court doesn't have the power to order a family to go to a parenting coordinator, that it has to be a consensual process.
Correct.
So that's something that people I find in my practice regularly don't appreciate. And when they want a parenting coordinator, I let them know that you have to bring them along. But let's assume, for argument's sake, you've been hired as a parenting coordinator or there's a file referred to you. What are the type of issues you would typically deal with as a parenting coordinator?
So our jurisdiction is basically anything that the parenting plan addresses with respect to transitions, activities, maybe changes to the schedule for holidays, day-to-day decisions for health and education, not necessarily where one would go to school, but certainly anything.
It seems that we've lost Elizabeth's connection.
Oh.
Or it looks like we've lost everybody's connection.
You've frozen, but I can still see me. Okay. Oh, sorry about Riverdale. As far as what okay, why? Because Andrew's gone. Okay. So, I mean, my process basically, we have a number of options. So parenting coordination isn't always the first option that I would suggest to people. At Riverdale, we also do mediation and mediation arbitration. So if somebody comes and says, well, we really just have a struggle with one issue in the parenting plan, I would probably suggest to them that they actually just do mediation arbitration, make a decision in one area, and then they could come back if there was another thing that needed to be dealt with. Parenting coordination is a minimum of 1 year term, if not 2 years. So you're really signing into a process for a fairly extended period of time. And that's not always what's needed when we're dealing with certain families. There are some where it's absolutely that term is necessary, but not everybody needs that term. I can't hear you now. So because of Zoom, I have clients all over the province, because once we do, I'd like to do my initial intake in person. But once I've had that initial intake meeting, I do most of my meetings like in this program right now on Zoom. And then even if people don't live that far out of the GTA, the traffic in Toronto is such that nobody actually wants to ever come downtown. So Zoom is my choice now as to, and it also keeps the emotional piece under control. People do not like being in the same room, but they're quite happy to share a screen.
Well, from my vantage point, I think sharing a screen is a lot better for a party that has separating spouses. So I think that's something that's really good, because I know whenever I'm engaging experts like yourself for my clients are concerned about the geography.
Mm-hmm. Yeah, for sure. And as they say, I think it's, if somebody really goes off the rails, and I can mute them, which is very effective. And people who are emotional, I say, take yourself off video. So there's a lot of options when you do use Zoom, and it just saves everybody time.
Okay. When do you think is the right time to be getting the parenting coordinator involved in a dispute? So the two parents, they've signed their parenting coordination agreement, they have their final deal, and when do they think is the right time to come and get your assistance?
So in a perfect world, the first piece of the process is to actually engage them in a bit of the education and coaching function. So there aren't any hot buttons at the time. And so we might work on communication, or we might work on whatever they've identified as things that they have as goals. The challenge is oftentimes before we actually get into that piece, an issue comes up. And so a lot of files I find are really crisis management files, and then I don't hear from them for months. So it's very much driven by the clients. Some of them engage you every week to facilitate their communication. Some of them, as I say, it might just be around the Christmas schedule. So it's, once or twice a year, maybe there's a travel consent that needs to be worked out. So it's very much driven by the client. I don't have any set schedule that you have to, contact me X number of, I check in once in a while and just say, how is everything? So it's very much dependent on where they're at in their process.
And do you suggest to people that they use apps like Family Wizard or Talking Parents to communicate? And if so, do you look at their communication online through the app?
I have quite a few families on our Family Wizard for sure, and they do give me access. I will go on if they ask me to go on to see a certain, stream of emails. I don't necessarily monitor them on a regular basis, mainly again because of cost. It's not probably a good use of their money or my time. But if that's a key piece of what they're asking to improve and for me to work on with them, then I will certainly use that as a reference point. But more and more people, you're on email, so that's their main way of communicating.
Okay, and the message I always say to my clients is, when you have, whether it's a parenting coordinator or your cases in front of the court, be cognizant of your communication. Don't use the nasty words and the nasty terms that you may feel that you want to use to describe your ex, because A, it's not child-centered and child-focused, and it's not going to help the two of you co-parent. And B, do you really want the judge to see that you did that? And that can include the way you call somebody. As an example, if the title you put on your email for your ex-wife is Wicked Witch, and she sees the email come in saying that you're addressing her as Wicked Witch, that's not going to help your cause, and it's not going to reduce the conflict. So you really got to be mindful of what you're doing. And when you're going to somebody like the parenting coordinator, they're not your friend, they're your parenting coordinator with a specific role, and you want to put your best foot forward to them.
So for some of my clients, my main role is to receive an email from one party, spin it into a different message or a different tone, and then communicate it to the other party. So there are, yes, clients that will not communicate with each other because of the history of that type of email. And so I am the conduit for emails that are more professionally and nicely written.
And what's the kind of case that a parenting coordinator wouldn't take? Because if somebody's saying to me, well, am I the right fit for this?
Yeah, well, first of all, any, kind of significant power imbalances that continue, you have to think about whether, that's something you're going to be able to deal with. And there are just people that, like, that all people in this business know, if they have zero capacity to actually move along the continuum, then I would think twice, unless I was very clear that I'm really only here to, as you say, call balls and strikes. And that I'm not going to be doing a lot of that education coaching function, because I don't think that that's actually going to work for these people. But mainly I just want to make sure that the conflict doesn't, the PC process doesn't ratchet up the conflict more than it already is.
And I've had clients who have said, I don't want the mediation side of it. I know we're not going to agree. I want to have somebody to call the balls and strikes. I want somebody to make a decision, and I don't want to have to run to court every time to get my travel consent signed or to get the passport from my former spouse.
Right. So I would say, there's two types of parenting coordinators. That are either the mental health side or the lawyer side. And I would say most people that want to come to me will say to me, I'm not that keen on working on the upfront education piece. I'm more interested in somebody who is going to, be reasonably quick to arbitrate. And I think that's why people are attracted or pulled towards lawyer PCs when they want that arbitration function to be, front and center, which not all mental health professionals are keen on that process.
Well, in my experience, sometimes it's hard because they frequently don't feel comfortable with writing arbitration awards. Not all of them, of course, but some of them, whereas a lawyer is going to feel more comfortable writing an arbitration award.
Mm-hmm. And you do have to follow it, a process. It's much less formal than the, a regular arbitration that I would do. Mostly written submissions. The decisions are quick because it's usually a time-sensitive matter. So it's, they're not as detailed and formal as a regular arbitration, but it does require you to know the act and evidence and then, yes, to write the award.
And there's also certain types of cases, because I have clients come in and they say, well, I want to change my parenting schedule in a fundamental way. I'm going to take it to the parenting coordinator, and there's an educational component to make sure the client understands, and I'm assuming you'd agree with me on this, that that's not the parenting coordinator's role to have a fundamental change to the parenting schedule.
Yeah, so in my PC agreement, it lists about 10 or 12 things that are within my jurisdiction, and then it says what is not, and that would be fundamental changes to the time that each parent has, substantial, we say, that would also affect child support. We can't deal with mobility, and we can't deal with custody. So if those are the things that people are looking for, then yes, you are going to have to bring a motion to change and go back to court. Some people do add in that we can deal with Section 7 expenses. We can deal with the actual activities, but not who pays for them. So a lot of times people will say, well, that's one of our biggest issues. So they will add that into the agreement that will allow us to determine who's actually going to pay and what activities they're going to sign up for.
Now, I know that you do a lot of parenting coordination work, and I know that's the topic of today's show, but do you also do mediation arbitration that, for lack of better words, would include the PC component, but then allow you to have the changes to the schedule or deal with mobility, deal with annual review of child support?
So I think with PC, you have to be careful about stepping in and out of those rules. I would probably, if they wanted to change, I mean, if they haven't written it in at the outset, I would be leery about stepping out to do a custody or a change in a schedule, not only just because, you know, you're taking on two different roles, but the real challenge with PC is once you've made a decision and written an award, it's very hard to get the loser back engaged. And something as significant as custody or parenting time, I don't think you could ever re-engage one of those parties in the PC process if you had been the arbitrator. So I would rather hive it off to somebody else, let them be the bad guy. And then they're going to come back to me and I'm still going to be viewed as neutral.
Okay. So if I'm understanding, your first objective really is not to arbitrate and get them to a mediated resolution that helps them get along, more than picking a winner on a specific issue than a loser, because your mindset is that's going to be better to keep them engaged in the process and hopefully make them into better co-parents.
Yeah, that is the goal, but I do quite a bit of arbitrations just because people won't agree on something, particularly schedules and, you know, who gets, you know, this holiday and that. But yeah, the goal is to obviously, I mean, my goal to them and what I tell them is I'm hoping at the end of the term that they don't need me anymore, that they've actually learned how to resolve their own conflicts so they can get away from all of us and just be with their own family.
How long is your typical term?
2 years.
And do you do different terms, or is it always 2 years?
No, some people want longer. Some people want a year. I won't take anything less than a year because basically you put in a lot of upfront work and then it's over. So I don't think it's beneficial for them. But generally speaking, 2 years is what people are signing up for.
And do most people continue in the process after 2 years, or do they want to switch, or they just go on their merry way and hopefully they're doing better at parenting with one another?
Yeah, it's a bit of a mix. You know, again, if I've done an arbitration or two, they probably want to go to somebody else. Oftentimes they've realized when they see, you know, how much money they've spent on who gets this and who gets that and pizza lunch and all of that, they realize that maybe better use of their time and money would be to try and work it out. And then some people do come back. It just very much depends. There's no sort of standard.
So I'm going to think back to some of the questions my clients ask me when I'm recommending somebody like you to do a PC file. And they say to me, well, Andrew, there's going to be certain issues that go on with the school. Let's say hiring a tutor. My spouse doesn't want a tutor. I want a tutor. And they say, well, I want the PC to speak to the teacher because the teacher is recommending it. Do you speak to collaterals like the teacher?
Yep. Yeah. So we, I mean, that's part of the sort of the upfront work and also the case management work. So I will include as many collaterals as possible so as not to repeat anything or not to have to get them in another process. So if I, you know, rather than interview the kids, I might start by talking to the kids' therapists. If a social worker's been involved, then, you know, maybe I'll talk to them. Teachers, anything that would give me a little more insight, with both parents' consent, obviously.
And is that something that's included in the agreement itself, which collaterals you can speak to, or is it something that's more open-ended or limited in the way you do your agreements?
Yeah, it's more that we would ask for consent. I find, you know, it's not, the consent from the parents is not usually the difficulty. It's actually getting the teachers and the school social workers don't want to get in the middle of a lot of this. So, you know, but if the family's already involved with a family therapist or some other professional, then I will try and reach out to them.
See, I've had cases where one side who doesn't want the child's counselor to speak to the parenting coordinator because they're worried that they're going to say all sorts of things that aren't very favorable to their position.
It's very threatening to both parents for sure. But, you know, and there's a limited it very much depends on the file, but usually there have been enough people involved with these families that you can get some information rather than getting them involved in a new process.
And sometimes it probably depends which side I'm sitting on at the time that I'm negotiating for my client. I may want the PC agreement to include the specific consent for you to speak to the collaterals that you think you need to speak to. Is that something you would feel comfortable with?
You know what, when the lawyers are executing the PC agreement, I'm happy for them to, if they agree to add in whatever they want. I don't let them exclude things that I've already, I already have in my agreement, but if they want to agree to add things, then that's fine. But there would have to be an agreement up front, and I don't get involved in that piece.
One of the things I frequently look at this, and this is more a strategy that may be mine, and I'm sure others feel the same way, which is if you're dealing with something that is trying to get the person who's going to make the decision all the information at the first stage before you sign the agreement, before you engage them, before you even know what the issue is, usually both parties are going to be okay with that person getting all the information. If you wait to when the dispute happens, one side may know what the answer from the expert is going to be and wants to keep the expert out of it. And
but I mean, realistically speaking, it's, your goal is to get as much objective information as possible, because you're obviously, just like in any of these files, you're hearing, one thing from one parent, one thing from the other. And so part of my goal is to, let them understand or help them understand that without that information, there's nothing I can do. I'm not going to make a decision based on what I read, for submissions from each of the parents. So it's, the challenge is they've all had a lot of intervention up to this point, and I think they're sort of process weary, which I understand.
And one of the reasons why I recommend this process to my clients is that I say it's far less expensive, because the option of engaging to deal with these kind of issues like travel consents is very expensive to hire me or even one of my junior lawyers to run to court to deal with a travel consent.
Mm-hmm.
Whereas in my experience, most of the time when the parties go to a parenting coordinator like yourself, it's the lawyers aren't even involved once the agreement is signed. It's the parties on their own. And I think I heard you say earlier, it's frequently done by email, maybe phone.
Oh yeah, mostly. Yeah, written submissions. No, my mantra to most of my clients is, when the PC agreement is signed, bye-bye to the lawyers, because the whole thing is to get them out of that process, to reduce the fees, and they split the fees for the PC. So rather than each paying a lawyer, I always tell them, if we're moving to arbitration, get some independent legal advice. If it's, if you want to write your submissions and then run them by your lawyer, but it's very rarely do I ever do an oral hearing in PC, although you have to offer it. It's just written submissions sent by email to each other, and then, a quick reply, and then off you go.
And I'm going to give an example of one that I can think of that I've seen before. Somebody phones me up. They say, my brother is getting married, and it's not on my weekend with the kids, and my spouse won't consent to me taking the kids to the wedding. Now, to a lawyer, that seems like a pretty obvious result, what's inevitably going to happen. But to go hire somebody like me to get you the order is going to be a lot of time and expense. And it's one of those things that as a parent, you're never going to forget that your former spouse tried to block the kids from going to your brother's wedding.
Right.
You're never going to forget that. And that's going to create more conflict. Contrast that with this process where probably you're going to engage someone like Elizabeth, who will first try and mediate the resolution of it, which may be trading off some time or something like that, to then even having that arbitration hearing by email. The cost of it is going to be a fraction of it, and it's going to be worth the hearing. And when I talked about somebody who wants delay, when you say that brother's wedding and taking the kids to the brother's wedding, the person who hasn't consented to it is sort of hoping that you won't even take it to court because it's going to cost you too much money, saying no.
Yeah. And those are, that's quite often what it is. It's schedule changes for special events. Most people have that in an agreement, and it's always a challenge, but my email goes out saying we've tried, we have been unsuccessful. we're moving into arbitration. Send me 4 pages, 10 point, single spaced by Friday at 5, and you can each have 2 days to reply, and I'll have my decision to you by Tuesday. Right, so it's quick.
It's quick. It's far more efficient and far less expensive when you're sharing your costs. I wanted to thank you for coming on the show today because I see our time is up. It's been a pleasure having you. For anyone interested in learning more about Elizabeth and her practice, you can visit her at www.riverdalemediation.com. The next Ask Andrew show is on October 21st at 1 o'clock. If you have any requests or ideas for future shows, please email them to us at info@feldsteinfamilylaw.com. And thank you for watching.
Thank you.